On January 17, 2025, President Joe Biden made a significant declaration. He declared the Equal Rights Amendment, or ERA, ratified. Biden stated that the ERA is now the law of the land. This declaration was met with both celebration and controversy. Some hailed it as a victory for gender equality, while others questioned its legality. The declaration itself does not immediately change the legal status of the ERA. It signals Biden's support and sets the stage for further legal battles. The ERA has a long and complicated history. Biden's declaration is just the latest chapter in the fight for its ratification. The debate over the ERA highlights the complexities of the American legal system. It also underscores the ongoing struggle for equal rights in the United States. The ERA's future remains uncertain. However, Biden's declaration has reignited the conversation about gender equality under the law. This complex situation requires a closer look at the history of the ERA. It is also important to understand the legal challenges that lie ahead. The Equal Rights Amendment was first proposed in 1923. Its purpose is simple but profound: to guarantee equal rights for all citizens regardless of sex. The ERA states, "Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex." This straightforward language was meant to ensure that women have equal protection under the law. In 1972, Congress passed the ERA and sent it to the states for ratification. The original deadline set by Congress for ratification was 1982. 35 states ratified the ERA by the deadline, leaving it 3 states short of the 38 needed for it to become part of the Constitution. The ERA faced strong opposition from conservative groups. These groups argued that it would have unintended consequences. They claimed it would undermine traditional family structures and lead to same-sex marriage. Public opinion on the ERA was divided, and it ultimately failed to meet the ratification deadline. Despite its setback, the fight for the ERA continued. Activists continued to push for its ratification. They argued that it was necessary to ensure full equality for women. The fight for the ERA gained new momentum in the 21st century. In 2020, Virginia became the 38th state to ratify the ERA. This victory was celebrated by supporters as a historic achievement. However, the victory was clouded in controversy. The original deadline for ratification had passed decades earlier. Additionally, 5 states that had previously ratified the ERA had since rescinded their approvals. These states were Idaho, Kentucky, Nebraska, Tennessee, and South Dakota. Opponents of the ERA argued that these factors rendered Virginia's ratification null and void. The legal status of the ERA became a matter of intense debate. Legal experts were divided on whether the deadline could be extended and whether states could rescind their ratifications. The National Archivist, who is responsible for certifying the ratification of constitutional amendments, refused to certify the ERA. The archivist cited the expired deadline and rescinded approvals as reasons for not certifying. This decision set the stage for a legal battle over the ERA's validity. The debate over the ERA's ratification is likely to continue in the courts. Supporters of the amendment argue that the deadline was not set in stone and that states cannot rescind their ratifications. They point to the fact that Congress had extended the deadline for ratification of other amendments in the past. They also argue that the Constitution does not explicitly allow for states to rescind ratifications. Opponents of the ERA maintain that the deadline was clear and that states have the right to rescind their approvals. They argue that allowing the ERA to be ratified after the deadline would set a dangerous precedent. They believe it would undermine the amendment process outlined in the Constitution. The Office of Legal Counsel, or OLC, which provides legal advice to the executive branch, has issued opinions stating that the ERA has expired. The OLC's opinions are not legally binding but carry significant weight. However, the OLC's opinion is not universally accepted. Some legal scholars argue that the OLC overstepped its authority. The debate over the ERA is ultimately a debate about the meaning of equality. It raises questions about how to interpret the Constitution in a changing world. The ERA's fate remains uncertain, but its journey reflects the ongoing struggle for a more just and equitable society.